assets held in a special needs trust. Let me just hit this button. Also, along with that SSI, here in Texas, we get automatic Medicaid if we're receiving SSI. Again, to keep Medicaid, we have to be poor and needy, so very limited income, limited assets. And the other biggie for us is our Medicaid waiver programs. We all know that a lot of us apply for these Medicaid waiver programs. We put our kids on an interest list, and it takes 7, 8, 10, even 16 years for some of these programs to come up to where our kids can use those resources. And so to be on that program, again, you need to be pretty poor. And so that is why we need these special needs trusts. Now, talking about SSI in particular, and this is going to be pretty similar to the other Medicaid programs, there are some assets that don't count and our kids can still get SSI. First of all, they can have up to $2,000 and they still can keep their SSI. So $2,000 in total assets. So if there's a bank account and then another account that combined, they have to stay below 2,000. You can have a house in your name and still be on SSI. You can have a car. You can have your personal items like computers and furniture. You can also have a life insurance if the face value is less than $1,500. So you can see the list there, but the biggies are the special needs trust and the ABLE account. Again, that's where we as parents can leave assets for our kids and let them have a high quality of life, but still maintain eligibility for these government benefits. So how is a special needs trust different from another trust? First of all, as I already mentioned, the beneficiary of the trust, the person who the money is going to be spent for, that individual has to be disabled. Could be a physical disability or a mental disability. Another thing that really is different about special needs trust is the beneficiary cannot have control over the trustee, over how the money is spent. So it's very restricted. There are a lot of trusts out there where the beneficiary can also be the trustee. In other words, I could create a trust for myself and I could be my own trustee and manage it. And then if I become incapacitated, someone else takes over. This is different with the special needs trust. Right from the start, no matter how capable the beneficiary is, they don't get to have control. And there is a stated purpose for a special needs trust, that it is to supplement and not supplant government benefits. What that means is we let government benefits pay for as much as it can, and then the trust kicks in to provide the quality of life that the beneficiary really deserves. So if there's already a program that's paying for housing, we let that program pay first. This is not a general support trust. If you know a lot about trusts, a lot of them are written to cover the health, education, maintenance, and support. This is not that kind of trust. Okay. And as I mentioned, the great thing about it is we're not going to count the trust funds or the trust property as a resource for SSI or Medicaid. There are two types of special needs trusts. There's a first-party trust and a third-party trust. First-party trusts are funded with assets or money that already belongs to the beneficiary with disabilities. The big thing to remember about first-party special needs trust is that it has a Medicaid payback attached to that type of trust. So what that means is if my daughter's Angela, if Angela has a first-party trust, then when she dies, whatever is held in that trust, whether it's a house or money, Medicaid's going to claim it. They can be reimbursed for all the money they've spent on her over her entire lifetime in every state she's ever lived in. So we try to avoid first-party trust if we can, but if Angela already has money in her name, say grandma left her some money and it's already in her name, this is the only kind of special needs trust she can use. So you can already see why planning ahead is real important, because what we all want to use is this third-party special needs trust. A third-party special needs trust is funded with assets belonging to anyone other than the beneficiary with disabilities. And so this one does not have a Medicaid payback. So the most common use for these third-party trusts are families who do their estate planning and they update their will to leave property to their child with disabilities to this type of trust. And that way we can leave as much as we want, and it's an extra source of funds to let our kids have the best life available to them, not be restricted to, being very, very poor to qualify for these programs. There are pooled special needs trusts, and these types of trusts can be either first party trusts or third party trusts. So they might have a Medicaid payback on them, they might not, depending on what type of special needs trust. But what the pool refers to is it's a lot of people pooling their money together, and a nonprofit organization acts as the trustee and manages all the money together, and there are sub accounts. So the most common one in Texas is the Arc of Texas. There's an Arc of Texas Master Pooled Trust. And if I have that for my daughter, what I do is I have an account, I give my money to that trust, the ARC manages it, and then she has her own little sub account that is invested, and I can ask for money for her benefit when it's needed. Okay. First party special needs trusts, a little more information on that. These are the ones with the Medicaid payback. They're also called self-settled trusts or D4A trusts, same thing, just different names. And these are very strictly, the rules for these trusts are very strictly set forth in our laws, in our statutes, in the codes. And there is a federal law that says a first party special needs trust can only hold assets of an individual under the age of 65. So this is not a trust that would work for an elderly person who loses capacity in their later years. It's for individuals who are disabled before the age of 65. It has to be set up by a parent, a grandparent, a legal guardian, or a court. Or if that individual has enough capacity, they could set up their own trust. I have this slide here about what is the definition of disability. And I know this is, we might follow up and have another conversation about Social Security, but this is the general definition of how you qualify to get disability payments from Social Security Administration, at least how you qualify medically. This is not getting into the financial or the work credits, but to qualify medically to get disability, you have to be, as an adult, unable to engage in any substantial gainful activity because of a disability that is going to last at least a year. And so what that means, substantial gainful activity, what that means is you're not out there working, earning a lot of money. And when I say a lot of money, Social Security every year updates what a lot of money is. And their definition is over $1,350 a month is considered substantial, or a lot of money, enough to where you are not considered disabled. So let me reword that. I don't think I explained that very well. So if you are earning more than $1,350 a month, you are not disabled by Social Security criteria, no matter what kind of diagnosis you have. It doesn't matter. If you earn that, they say you are not disabled. This is the definition for an adult. It is different, obviously, for a child. Anyone under age 18, we don't expect them to be out working, but that's just important to understand. So these trusts, these first party special needs trusts, are for people who qualify under this definition of disability. Already mentioned, set up by parents, grandparents, guardians, or the court. And so what that means is if a parent dies and leaves a bunch of money to a child in their name, and now we're worried about them losing their government benefits, and we want to move the money into a trust, if there's not a living parent or a grandparent or a guardian, then we might have to go to court. So they can get expensive. Again, another push to get this all taken care of while you're still young and alive and can manage this, do the estate planning for your kids. Main thing to remember about these trusts, again, Medicaid payback. So we want to try to avoid that Medicaid payback if we can. Special needs trusts, what do they use for? A lot of people are really nervous about how, when they have a special needs trust set up, they don't want to ask for any money from the trust. The trusts are set up to better the lives of the person who is the beneficiary of the trust. So that means the trust should be used. The trust can be used to pay for clothing or entertainment, going out, going on vacation. It could be used to to purchase pet supplies. It could be education, furniture, could be used for legal fees. You know, the lawyers got that in, CPA fees. So these trusts should be used. They're meant to be used to better the lives of the individual with disabilities. Can the trust be used to pay for food and shelter? This is a little tricky. And if you read online, you know, if you're just trying to Google information about special needs trusts, a lot of times you will read a statement that says special needs trust can't pay for food and shelter. The reason that misunderstanding is out there is because it used to be that a lot of special needs trusts were drafted to say no paying for food and shelter. And that is because there are some government programs that are specifically designed to cover food and shelter. And one of those is SSI, Social Security Disability. But almost all special needs trusts are drafted nowadays, and they should be drafted to allow the trustee to decide whether or not to pay for food and shelter. And why would the trustee decide maybe yes, maybe no? The reason is because if a trust is paying for food and shelter, it reduces the amount of SSI by 1/3. So there's, without getting into a lot of details about SSI, there's a maximum amount that a beneficiary can get every month. In 2022, it's $841 a month. Well, if a trust is paying for the apartment or paying for food, then what happens is the SSI gets reduced from $841 to $560 or $61. And so it's a pretty big hit. And so there are a lot of ways around it, which we may get into, but that's why sometimes the trustees feel like they are not allowed to pay for food and shelter, but typically there will be a clause in the trust that says if the trustee feels like it's in the beneficiary's best interest, you can pay for food and shelter. For example, if my daughter is getting $841 a month, I do not want her stuck with, you know, an apartment that has to be paid for with $841 or less. So I would want her to use her trust to help supplement that cost. Okay. What do you fund a trust with? You know, where do you get the income and the assets? What can go into a first party trust? It could be a bank account. You know, you could have life insurance pay into it. You could actually put a house in a trust by just signing a deed so that now the trust owns the home. Say you have a car accident and you get a personal injury settlement, you could move that money into a first party trust. Child support can also be put into a trust for someone who is pretty significantly disabled. There's lifetime child support available in Texas, and we can have the child support paid directly into the trust. We can also have military SBP payments for anyone who's in the military. Is anyone here in the military? Anyway, we'll just keep going. I guess I should keep going since we're recording this, but talk to me after if you're in the military and we'll get into more detail on that one. Basically, a long time ago, you had to choose if you were in the military whether or not you wanted to have this military benefit pay to your child, or you wanted them to keep their other programs such as Medicaid waiver programs, SSI, SSDI. And now there's a way you can keep both by having the military SBP payment paid directly to the trust. Child support, I'll just mention a couple things on that. Child support is available for a lifetime for a child who is significantly disabled. So even when they're past the age of 18 and out of high school, child support can still keep coming in. But if you don't have the child support directed to the trust, it's going to count as money for that individual who's getting the support and will likely disqualify them from SSI and other government benefits. So the way we avoid that is we get the child support court ordered to go to the trust, and that allows them to keep their support and also get the SSI or Medicaid waiver benefits. Interestingly enough, some people think we can assign child support to an ABLE account, and you cannot do that. We'll talk about ABLE accounts in a minute, but child support has to go to a trust. Okay. There's certain income, though, that you can't just have go to a special needs trust. And so we won't get into a lot of details, but military families, there's some certain military payments that you can't just have them pay into a trust. You can't just have Social Security payments pay into a trust. So sometimes we can make income not count to keep someone eligible for their government benefits, but you can't just put any old income into a trust and have the income not count. And I think I need to back up a little bit. I'm not sure I explained that very well. So when we're determining whether or not someone is eligible for these SSI programs, Medicaid, they're going to look at how much income that individual has coming in and what their assets are. And so that's why we need to make sure there's not too much income or they're not going to be eligible. And also their assets have to stay below 2,000. So we know we can move property, we can put bank account funds and homes and things like that into a trust, and it's not counted as an asset, but we can also not count certain income, and that would be like the child support and the military payments. Okay. All right. Third-party special needs trusts. These are a different type of trust. These are the types of trusts we use when we are trying to do estate planning for our kids. We want to make sure we can leave money for their benefit after we're gone, and we don't want to mess up their government benefits. Okay, so to have a third-party special needs trust, the beneficiary has to be disabled, and same situation as first party trust, we can put cash in there, we can put stock, we can put real estate. There's no limit on the amount of money that can be held in a third party special needs trust. And the great thing about these third party trusts is the person who's setting it up, the grantor, or we call it a settlor, that person gets to decide where all the money goes when the beneficiary dies. So what that means for me, I create a trust, and I can put in my will, everything goes to my husband when I die. But if my husband's already died, then I want to give all my property to my 4 kids, and whatever share I want to leave for my daughter, Angela, goes to her special needs trust. And because I'm planning ahead, I'm creating the will and the trust and doing it all ahead of time, I can have it go to a third party special needs trust, because it's never going to be owned by her. It's going to go directly to the trust. And so then in my trust document, I can say, and when she dies, whatever's left in this trust goes to all my other kids. So, I can leave whatever I want to this trust and set it up and avoid that Medicaid payback. Okay. There's different ways you can set up these third-party special needs trusts. You could have it be part of your will, so the trust is not in existence until you die, and that's when it comes into existence. We call that a testamentary trust, meaning it's established under the will. You could do something similar if you have a revocable living trust or some other trust for your benefit. You could establish a special needs trust as part of that. Or most commonly, we make it a separate document. We call that a standalone trust. We create a separate document, and we have a lot of flexibility when we make it a separate document. We can make it be a revocable trust, meaning it's easy to change, or we can have it be irrevocable and have some terms set. And there are reasons for both of those. Some of the reasons why you might want to consider it to be a separate document is because it might be that grandma wants to leave some money to the granddaughter. If my mother wants to leave something to Angela, I need to have a document, a separate document, so the trust is already in existence, so there's a trust to leave it to. If I just have a trust under my will, then it's not in existence. So when grandma dies, there's no trust to leave it to, and then we have to create a new one. Also, when you have a separate trust document, it's easy to be much more creative and much more detailed. And if there needs to be a change to your will or a change to the trust, it's going to be a lot easier, a lot less expensive than having it all combined in one document. Okay, I'm going to keep going. Interrupt me if there's questions. Otherwise, I'll just keep going through this. Okay. One of the toughest decisions on these trusts is figuring out who the right trustee is. Typically, we have parents serving as trustees for as long as they're alive, and that's usually a pretty easy decision. Okay, I'll be my daughter's trustee. If I die, my husband will continue. But what happens when the parents are not around to be the trustee? It gets complicated. You could say a sibling could be the trustee, or just a friend that you're comfortable with. You could also name a bank, a trust company, a professional trustee, or a nonprofit organization. You cannot let the beneficiary with disabilities be their own trustee. So what is the trustee doing? The trustee has the responsibility to say, yes, I'll pay for this, or no, I won't pay for that. So for example, if Angela has a special needs trust and she wants to go on vacation, then she could tell her trustee, I really want to go on vacation. And the trustee would say, well, where are you going to go? Well, okay, I'll let you go here. And this is what I'll pay for. And this is what I won't. And it's up to the trustee to say yes or no. You know, a common example is the car. A lot of times the beneficiary says, I need a new car. And the trustee might say, okay, we'll get a car, but it's not that car you picked. We're going to choose a different car. So the trustee would look at the trust document to get ideas of how the grantor, the person who set it up, wanted the money to be spent. So in my trust for Angela, for example, I can leave instructions that say, I really want Angela to go on a trip every year with her sister, and this is how I want the money to be spent. And in fact, I have that in her trust. And then her trustee can read that and say, all right, this is what her mom wanted. We're going to pay for it. If I didn't give any instructions, the trustee uses his or her best discretion to decide whether or not it's a good idea. And typically they figure out, how much money's in this trust, how long does it need to last? And they just make the decision that they think would be in Angela's best interest. So, the trust document itself, as parents, we can give a lot of instructions, or we can leave it pretty general, up to the trustee to decide everything. Okay. So that trustee has a lot of power, a lot of control over how this money is going to be spent. So you want to think carefully about who is going to have that power, who's going to make those decisions. It's very common as parents to just assume our other kids will step in when we're not around. And a lot of times they do. But I'm going to tell you some of the things to worry about. Okay. One thing I would say is, if you have a sibling act as the trustee, they may get completely overwhelmed. There is so much to figure out in this world we live in. What's the difference between SSI and SSDI, Medicaid versus Medicare? When can I pay for housing? When is it going to cause a problem? What's the first party trust versus third party? It's a lot to put on our other children. And so a lot of times it's just too much. And maybe our kids just don't want to do it. It also, a lot of times there's a conflict of interest built in. And I'll use my family, for example. If I have Angela's brother acting as her trustee, every bit of money he spends on Angela is less money that's going to come to him one day, or if he dies before her, that's going to go to his kids. So in some families, you have to think, is that going to make the trustee not want to spend money, because it's going to be less money coming eventually to his own family? So you got to look at that option. The other thing I always worry about the most is siblings are absolutely the very worst about messing up these special needs trusts. And the way they mess them up is they borrow money from the trust. And it's not that they're trying to steal money. They tell themselves, well, look, if mom and dad were alive, they would really want me to just borrow this money to buy a new car. My wife and I really need a new car. We're just going to borrow the money, then we'll pay it back. Angela's got a lot of money in her trust. And that happens a lot. And when somebody uses money from a special needs trust for a purpose that is not for the benefit of the individual with disabilities, it's no longer a special needs trust. It doesn't, all the money in that trust now counts for Angela. And so what happens a lot of times is siblings mess it up by taking money for themselves, and it causes all kinds of problems with benefits. A lot of times the money's gone. So it is something to really think about. Is it the right idea to have a sibling as a successor trustee? And I'm not saying it's never good. In fact, I have siblings as successor trustees to my husband and I, but it's something you should really think about very seriously. If it's not a great setup for your family, you could look at a bank being a trustee. You could look at a nonprofit organization such as the Arc of Texas and do a pooled trust. Sometimes, there's a lot of different options. And I will say just one thing on the corporate trustee, having a bank be the trustee. The downside of the bank, besides the fact they're going to charge a fee, and so is the nonprofit organization, they're going to charge a fee of 1.2% to 1.5% of the total assets. That's going to be a yearly fee. So it's going to be a cost. But also, banks a lot of times won't agree to be a special needs trustee unless there's a whole lot of money in the trust. So figuring out the right trustee usually takes a little bit of time, a lot of talking, what's best in this family situation. So if it's a a tough question. It's tough for all of us to get that, figured out to where we're comfortable. I just want to mention a trustee of a special needs trust is not a guardian. So a trustee cannot start making medical decisions for the beneficiary, can't just sign lease agreements, but they just manage the trust funds. I've covered this, so I'm going to skip through these slides. I want to get to ABLE accounts. So in summary about the special needs trusts, special needs trusts are very valuable. It keeps our children eligible for their needs-based government benefits. The programs where they have to be poor, have very limited income, limited assets. This is a great way to keep them eligible for those programs. It also lets our kids have extra funds to enhance their quality of life. It also gives them assistance with money management. Sometimes our kids aren't even on those types of programs, but they need a lot of help managing the money. So you've got a trustee in place that can help invest money, decide when money should be spent or shouldn't be spent. So that's a great value. It's also a good way to protect against financial abuse, from someone taking advantage of our kids if the money's in their own names. And it can avoid a guardianship of the estate. We didn't get into that, but in Texas, we have guardian of the person, which makes medical decisions and chooses where somebody will live. And we have guardian of the estate, where we manage money for the person who needs help. Guardians of the estate in Texas can be an expensive process. And once you're under a guardianship of the estate, you need to hire a lawyer every year to do an accounting. And so what we do is we try to find other ways to help the money get managed without needing a guardianship. So having a trust in place with a trustee managing money, a lot of times that avoids the need for a guardianship of the estate and the need for a bunch of attorney's fees every year. It's important once you establish a trust to report it to the Social Security Administration or the Medicaid office. It's something that will need to be evaluated by their team to make sure it qualifies as a special needs trust. So you've got to be careful to make sure you get it turned in, make sure you use an attorney who understands how to draft this, and make sure you get it reported and evaluated. Don't just sit on it, because it is possible in the world of Social Security benefits to end up getting a bill for 2 or 3 years worth of payments that were not supposed to happen, and Social Security asks you to pay them all back. So if you don't report a trust and later on they realize you had a trust that didn't qualify as a special needs trust, they can ask you to repay all the money that was paid out on your child ever since that trust was funded. So it's kind of scary. You got to make sure you report these trusts. Okay. Any questions on trust before we move to the ABLE Act, and we'll kind of compare this with the trust? Okay, I'm going to keep going. All right, ABLE accounts. Those are fairly new. The ABLE Act was signed in 2014, and it took a little while to get ABLE accounts rolled out in all the states. So the ABLE Act provided for a tax savings program for individuals who were disabled before the age of 26. And the ABLE Act required states to create their own programs. Texas took a few years to get going, but now most states have ABLE Acts. I think all but 4 have their own ABLE account programs. To be eligible to have an ABLE account, again, you have to be blind or disabled, and it's got to be prior to the age of 26. So you don't have to have your account set up before you hit the age of 26, but you must have been disabled before the age of 26. If you qualify for the age criteria and you are already getting SSI or SSDI benefits, it is super easy to establish an ABLE account. So this is going to be very different from a trust. A trust, you're going to need to go to an attorney, work with an attorney. It's probably going to be a pretty significant cost to get that trust up and going. An ABLE account, it's not going to cost anything, and it is easy as can be. So within about 10 minutes, you can have an ABLE account. You just do it online. If the beneficiary of the ABLE account isn't receiving SSI or SSDI, it's a little more difficult, but it's not bad. You just need a physician's statement that this individual is disabled. Okay, so pretty simple process. There is some legislation that's pending. If it passes, it would change the age criteria from 26 to 46. And what I'm hearing is it's likely to pass. So if this passes, the ABLE accounts would be available for anyone who is disabled before the age of 46 instead of 26. And estimates are that would allow ABLE accounts to be available for more than 6 million other individuals with disabilities. So we'll see what happens there. You can get an ABLE account in a state other than Texas. Some states allow out-of-state residents. Now, Texas, we're a little snooty, and we will not let anyone have a Texas ABLE account unless you are a Texan. But if you don't like the Texas ABLE account, and you want to go to another state, there's about 28, 29 states that allow residents from other states to join their programs. And each state is a little different. So you could go compare, Texas with Ohio, with Virginia, with California, with different states, and see which program you like. They're not that different, but some of them charge a higher minimum enrollment fee, a minimum contribution fee, I should say. Some of them charge a monthly fee that is higher than another state, but I don't want to overstate this. Texas, we charge $3.50 a month, and that's pretty common. So we're not talking a huge difference, but there are differences in how money's invested and the types of cards you can get linked to the program, to the ABLE account. So you can look and compare states. If you're in a state that has state income tax, some states, deduct that, but obviously we're not worried about that in Texas. The ABLE account owner is the person with disabilities. The manager of the account it could be that person with disabilities if they have capacity to manage their own account, or it could be an authorized legal representative. An authorized legal representative for an ABLE account could be the parent, could be a legal guardian. It could be a power of attorney. In some states, it can be the representative payee. That's the person who's been appointed by the Social Security Administration to manage Social Security funds, not in Texas. So in Texas, you've got to be a parent, a guardian, or a power of attorney agent, or the individual with disabilities themselves if there's capacity. Okay, this is really important to understand. ABLE accounts have limits. This is different from special needs trusts. I was mentioning earlier, there's no limit to a trust. I can leave, $50,000 to a trust, and it could have $1 million if only I had $1 million to leave to my daughter's trust. But you could have any amount of money. You could have any type of property. ABLE accounts are not like that. The most you can put into an ABLE account every year is $16,000. And that changes. That's tied to the IRS annual gift tax exclusion amount. So that's the 2022 number. If the beneficiary with disabilities is working, they can also add an additional $12,880 in their earnings. So, but if they are not able to work, we're stuck with the $16,000 per year. And so think about that. That means that while you can get an ABLE account for free, it's not going to work to replace special needs trusts, because I can't in my will leave a bunch of property to an ABLE account if it's got a limit of $16,000 per year. And that's a total contribution. So that would be from everyone who donates to that ABLE account. In total cannot exceed $16,000 in the year. Also, you can only have one ABLE account per beneficiary. So for divorced couples, if mom gets it first, that's the ABLE account. If dad sets it up first, that's the ABLE account. Only one per beneficiary. That's different from special needs trusts, where there's unlimited amounts allowed for a beneficiary. Anyone can contribute to an ABLE account. It could be me as mom, it could be grandma, it could be the beneficiary putting her own money in. Like I said, Angela could work, or maybe she just gets a gift. She can put her own money in, but all the contributions have to be cash. So you can't put a house, you can't deed a house to an ABLE account, only cash, and with that limit. Okay. If someone is receiving SSI, the ABLE account has to stay under $100,000. If it goes over $100,000, the SSI is suspended. If it goes under $100,000, again, you don't have to reapply for SSI. Your SSI will kick back in. but it's got to stay under 100,000 for SSI to still be paid. Medicaid is a little different. We can go up to $500,000 and still keep Medicaid. But I don't know why anyone would want $500,000 in an ABLE account in Texas, because ABLE accounts also have a Medicaid payback. Now, if you're in another state, not all states have this Medicaid payback. And there's a chance that over time, maybe Texas will get rid of the Medicaid payback. And if they did, this would be a much more useful tool for us as parents. We could, we could donate a little bit of money and it would grow tax-free. We could donate every year and it would grow and grow and grow. And if we didn't have to worry about the Medicaid payback, that would be great. But in Texas, there is a Medicaid payback. And you can't just go join another state without a Medicaid payback. If you are a Texas resident, you have a Medicaid payback, no matter which state's ABLE account you use. The payback is a little unsettled how it works because these are relatively new. And remember, since you can only put 16,000 per year in, there's not a lot of ABLE accounts that have grown very big yet, because we just started having ABLE accounts a few years ago. But there is a big push to get rid of these paybacks because it's sort of lessening the appeal. And I hope that happens. But right now, we still have a payback. The payback, by the way, the Medicaid payback is also a little different compared to that first party special needs trust. The first party special needs trust, the payback on that is any payments that Medicaid made for that beneficiary over their entire lifetime in every single state. And so, again, I'll use my daughter as an example. So if we've lived in California and Massachusetts and Texas, and so if she had a first party special needs trust and died, we would have to get all the Medicaid payments from all those states where she's lived. That is, and it's her whole life. Excuse me, that is different from an ABLE account. The payback is only after the ABLE account was set up. And that makes a difference in some cases. ABLE accounts are fashioned after 529 college savings plans. So college savings plans are under 529C, that part of the IRS code. ABLE accounts are actually under the same section, created under the same section. They're 529A plans. So they're very similar, and they're specifically designed to allow a family who has set up a 529 college savings plan for a child who has significant disabilities to be able to roll over that money from the 529C plan into the 529A plan. And there's no penalty. It doesn't cause any tax problems. So again, 529 college plans are set up so that the money can grow tax-free, and it's a great way to save for college. If we find out that our kids aren't going to be able to go to college, the 529A plan, the ABLE account, can take that money from the college savings plan and continue to grow and be used for a lot more reasons other than just college. Again, the rollover, it still can only roll over 16,000 per year, and you've got to have the same beneficiary or be in the same, or be a family member. I hope that made sense. Okay. Once some money's in the ABLE account, the manager decides how to invest it, and you get to decide on your own if you want to be really safe and use FDIC insured bank savings options only, or if you want to be aggressive. And you can set the percentage. So I could say, well, I want 25% to be aggressive and 50% to be moderate and 25% to be bank safe. So you can change your mind, but you as the manager decide how to invest the funds in categories. Okay. ABLE accounts can be used to pay for qualified disability expenses. So this is the general term. How is money spent from the ABLE account? The money can be spent on anything that makes the individual with disabilities, makes their life better, for maintaining or improving health, independence, or quality of life. And the IRS has said specifically this includes housing. So we can use ABLE accounts to pay for housing. And because of this language in the IRS regulations, if an ABLE account pays for housing, there is no reduction in benefits for SSI. So again, another difference between special needs trust and an ABLE account. If a special needs trust pays for housing, the recipient is getting SSI, then that SSI is going to be reduced. But if the ABLE account pays for housing, there's no reduction in the SSI. So what happens a lot of times is people have money in a special needs trust, and then they move money from the special needs trust to the ABLE account, and then the ABLE account pays for housing. And that's a way to keep the SSI a higher amount. There's lots of ways to get the money out of the ABLE account. You can, you do it online, you request online, but you could do bill pay. You know, you could have the ABLE account set up to pay for cell phones. You could order a check from the ABLE account. You could use a debit card that it gets attached to the ABLE account, or you can transfer from the ABLE account to another account to reimburse somebody. For example, Angela, my daughter, her ABLE account actually helps to pay the housing expenses, and I can just transfer it from her ABLE account directly into my checking account, her share of the household expenses. So it's pretty easy to manage. The debit cards are a great feature of the ABLE accounts. You can preload a debit card. So if your child is pretty independent, you want to encourage that independence, you could preload a debit card and specify how this money is going to be used. And your child could use that debit card anywhere they use a Visa, but they can't turn it into cash. But it's a great way to give a little bit more independence. And by the way, you can also link that type of a card to a special needs trust. That's typically called a TrueLink card, and you could preload the card and your child could have some independence to go out to a restaurant, or, well, let me clarify. If you're going to go to a restaurant, use the ABLE card, but, you know, go purchase some clothing or go out and do a movie or something like that. Okay. I think I'm going to, well, let me hit a little more detail on the ABLE and in-kind support maintenance. I want to make sure we have plenty of time for questions, but I mentioned before that ABLE accounts are used to eliminate that penalty on SSI. So SSI, remember, that is the disability for people who don't have enough work credits or are not qualifying under their parents' work credits. And let me just take a step back. When our kids apply for Social Security disability, if they haven't been able to work, they're not going to have the insurance from paying into the system. And so they're likely going to end up on this needs-based program, SSI, Supplemental Security Income. But if they remain disabled and they stay on this program, and then down the road, they now have a parent who becomes disabled themselves, or the parent starts drawing Social Security retirement or dies, then that person who's receiving SSI can switch from SSI, the needs-based program, to a program called Childhood Disability Benefits. And that is a type of disability program that is not needs-based. So what I'm saying there, you know, when I'm paying my FICA taxes, I'm paying for insurance for me if I become disabled, but I'm also paying for insurance for my children who are either minors or disabled adults. And so when I retire, I will get my full retirement, but because I've paid into that system, if I have a child who is disabled before the age of 22, and she's continuously disabled since that age, and she didn't get married, then she can actually draw off of my work benefit. She will take 50% of the amount that I'm getting for my retirement. And then when I die, it goes up to 75%. So if I retire, Angela can be drawing off my work record. And then if her dad retires, his benefit is higher in our case, so she would switch to his work record. So there's ways that you can start out on one of these needs-based programs, but move from that program to a different program that is not going to look at income and assets. But for a lot of our kids, they might spend many years on an SSI and needs-based program. And that's where Social Security is going to really look at all of the income. And there is a type of income called in-kind support and maintenance. And what that is, ISM income, that just basically means somebody or some entity, a trust, is paying for food and shelter. That is what in-kind support maintenance is. There's other kinds of income that we look at also, and we won't go into a lot of details. You know, it could be just from earnings or unearned income. Deemed income means mom and dad's income counts for kids under 18. A spouse's income counts for another spouse. But going back to in-kind support and maintenance income, The general rule is that if you live in someone's house for free, your SSI is going to be reduced by 1/3 of the maximum benefit. So every year there's going to be a maximum SSI benefit. This year it's $842, 841, and it gets reduced by 1/3 if Angela lives in the house for free. If she doesn't pay her share of expenses, she doesn't get the full amount. It'll get reduced by 1/3. And so how you get around that is you have the SSI recipient start paying their fair share of expenses. So if they live on their own, they pay their own rent. And if they live in the house, they pay their fair share of the housing expenses. And the Social Security Administration tells us exactly which expenses to count. There's 10 items that they're looking at. So it's the mortgage or the rent, it's electricity, water, sewer, garbage. Notice it's not cable, it's not cell phone, it's these 10 items. And so what we do is we figure out what are the household expenses total and how many people are living in the house. So in my case, I would add up all these expenses and I would turn in my, copies of my bills to Social Security and say, okay, there's 3 of us in the house, Mom, Dad, and Angela. So she needs to pay 1/3 of all those expenses. And when I do that, if she starts paying her share, she'll get the full amount of SSI. But what if she doesn't have enough money to pay her fair share? Say we have a mortgage and the 1/3 share of the mortgage is too much. She doesn't get that much money. Well, then I can either do a lease agreement, have an agreement with her where I have her pay room and board, or I can use an ABLE account. I'm not a huge fan of the lease agreement in a lot of cases because I think that if I have a lease agreement with Angela, then I think that's income for me and I don't want to pay taxes on that. Some CPAs say one thing, some say another, but I don't want to go down that road. Also, I want to claim her as a dependent on my taxes. So I don't think I want to treat her like a tenant because I think that could be problematic. So I personally like the ABLE account, but they both work. But I'm going to tell you how to do the ABLE account since that's what we're talking about. So what I do on the ABLE account is I donate money to her ABLE account. Anyone, remember, can donate money to the ABLE account. And once the money gets there to the ABLE account, it's considered Angela's money. She is the beneficiary, so she owns the money, whether it was her money that went into it or grandma's money, it's considered hers once it gets to the ABLE account. And as we know, ABLE accounts can pay for housing. So this is how we can get money to be used to pay her fair share of expenses. And so an example there, if Angela's fair share is $900 a month, then I can report that. I can do those calculations, tell Social Security her fair share is $900 per month. And I tell them she's going to pay $500 from her SSI and $400 from her ABLE account. And now she gets the maximum benefit. So if this is something interesting to you, then reach back out to me and we can go over that in more detail. But I know a lot of you apparently have kids that are getting closer to the age of 18. If it turns out that as your kids hit the age of 18, that may be a good time to apply for some kind of disability benefit. And if your children end up getting SSI, then this will be something that you'll want to look at. There may be a way for them to get a higher amount of SSI even if they're living in your home, by letting your kids help pay their fair share of expenses. Okay, so this is kind of a summary sheet comparing special needs trusts and ABLE accounts. Again, both are for disabled beneficiaries. Special needs trusts, we can have as many as we want. ABLE accounts, only one. The ABLE accounts allow money to be invested and grow tax-free. That's not true for a trust. You will pay taxes on the growth, the income that's generated by the trust. Special needs trust, unlimited types of property and amounts of money that can go into the trust. ABLE account that has those yearly limits, and the type, it can only be cash going into there. And remember, Medicaid payback, no Medicaid payback on a third-party trust, but a first-party trust does have a Medicaid payback, and an ABLE account in Texas, as of now, has a Medicaid payback as well. So again, a lot of times we end up needing a combination of all of these different types of trusts and accounts. So, excuse me, you just look at your particular situation and figure out what is best for your family. And that's kind of the summary. I hope one of the things you got out of this presentation, it really is critical to do estate planning if you have a child with special needs. Excuse me. You want to make sure that, well, we all want to make sure that we don't spend all this time getting our kids these great government benefits to cause problems by leaving money to them in their name. But we also don't want to just not provide for our kids. A lot of times I hear parents say, well, I'm just not going to, I don't want to worry about a special needs trust or an ABLE account. I'm just going to leave all the money to Big Brother because he'll take care of little sister. And the scary thing about that is if Big Brother ends up with his own creditor problems, files for bankruptcy, or gets sued. Maybe he ends up in a divorce. Maybe he dies. There's about 50 ways that that is a very dangerous strategy and the money can be gone. So I'd say estate planning is really important. Hopefully you have many, many, many years to get this done. You know, hopefully you got decades to get it all together, but it is something to think about and to be safe, you know, to get done as soon as you can. Okay, I think I'm going to stop there. Here's my contact information. I'll take your questions, but feel free to call my office if you need more information, but I'm happy to answer your questions now. So, and if you want to, oh, here we go. I'll stop this share. I think I've learned how to do it. Maybe we try to do this together. Okay.
If you have a question, you can just unmute yourself and ask your question. Thank you, Allison.
I had a question. It sounds like, if I understood it correctly, the ABLE accounts are specific to the state that you're in potentially. If you, let's say, open up an ABLE account, you know, in Texas, but with the special needs trust, is that something that you can move from state to state? If, let's say, you were living in Texas now, but then, you know, in 5-10 years you move to another state, would that special needs trust remain the same? Or like the ABLE account, would you have to like transfer it to whatever state you were?
Yeah, that's a great question. So just to clarify on the ABLE account, you might be able to move to another state and have an ABLE account in a completely different state. That just depends on the state rules. So again, if you set up a Texas account and you moved out of Texas, you got to change it. But if you started with an account in Ohio or Virginia, you don't have to change it. But special needs trusts, so most states have their Medicaid programs eligibility pretty much mimic eligibility for SSI. So when most attorneys draft special needs trusts, we're drafting to make sure someone is eligible for SSI, which is a federal program. So most of the time, a special needs trust that you have drafted in one state is going to transfer to another state just fine. The only difference I would say to watch for are these Medicaid waiver programs that every state has. Each Medicaid waiver program has its own rules. And so I can tell you in Texas, if you qualify for SSI, you're going to be fine with all of our Medicaid waiver programs. But if you go to another state, they might have some particular rule. You know, so it's always good to sort of check with the new state you're living in, and especially look at those Medicaid waiver programs. But usually it's going to work. I've only heard of one state, and it's Arizona, that doesn't like a statement in the trust that you can move money from the trust to an ABLE account, and they were denying some trusts if that statement was in there, but then there's new regulation, so I think that's gone away. I think you're going to be pretty safe, but it's always a good idea to check. And now a will is a different thing. So how you get the money to the trust is typically through a will giving instructions. Well, every state is very different on its rules for probating a will. In Texas, it's really easy to do. It doesn't take very long. It's not super expensive. But if you go to a state like California or Illinois, apparently it's just a complete nightmare to go through probate there. And we have rules in Texas that make probate much easier if we have words in the will such as independent executor, no bond. You know, there's certain terms that we use in Texas that are not used in other states. So if you come to Texas with a will from another state, we'll honor it, but it might not be as easy as if you'd done your will in Texas. So the trust is probably fine, but you probably want to update your other estate planning documents, or at least look into that. Did that answer your question, Sarah?
Absolutely. No, thank you so much. No, that was really helpful. I really appreciate it.
Good, good. Other questions?
Allison, this has been such a great presentation. Thank you for your time and your expertise. The question I have is that if we already have a 529 established for our daughter, is it something we would have to transfer then the 529 to an ABLE account? Let's say, down the road, if that's, how things progress, or I guess how would it work, with an ABLE account if you already have a 529 established?
Right. Okay. So the reason you would want to look into transferring it is because you don't want that 529 plan to cause your daughter to be ineligible down the road. Okay. So right now, how old's your daughter, by the way?
She's 9, and she came up for MDCP, and that was one of the things that they had talked about that might have been, an exclusionary thing with the 529.
Right.
There wasn't a lot of information available. They were going to have to, get back to us and stuff, but I can see where you're getting at with that.
Yeah, the reason it's so confusing is because right now, because she's so young, chances are she's not the owner of that account. So it's not an asset. When you look at these programs like MDCP and Medicaid waiver programs and SSI, what they're looking at is what assets does this individual have? And an asset for them is anything that can be converted to cash. Okay, even if there's a penalty, even if you have to pay a bunch of taxes and some other penalties, if you can convert it to cash, it's an asset. So for example, if you get a life insurance policy for your child that has a cash value, and one day, they have the ability to convert that to cash, that just became an asset. So ABLE accounts, 529 plans are confusing because usually the beneficiary has no right to convert that to cash. But you want to think down the road, what happens when you die and your husband dies? Is she going to be the owner of that account now? And it's just risky to have that out there because a lot of times that's the default. And I've seen that a lot of times where families, they don't realize that their child could convert something to cash down the road. They've been on government benefits, and all of a sudden, the Social Security Administration realizes there's some insurance policy out there with a cash value or some asset, and they make that person pay back a year or 2 years worth of benefits because they had that account. So my recommendation would be start rolling it over. I don't think it's going to be a problem for her now when they look into it. I don't think it's going to cause a problem, but I probably would move it to an ABLE account just to prevent any problems down the road.
Thank you. That was helpful. Thank you.
Good. Great questions. Any other questions? Do you all feel like, whoa, that was a little overwhelming? I know it's kind of a lot, kind of the simple summary. And I wish I would have started with this because I felt like I got into it and I was a little bit like, oh, I don't know if I gave a good opening overview. But the way you want to look at it is my child going to need these government benefits? Obviously, Jessica's already shared, in her case, yes. And in a lot of our cases, we know that it's going to be likely needed. If we're not sure, it never hurts to plan to keep our kids eligible for these benefits. If you want to make sure your kids are eligible, then you'd want to do the estate planning to make sure that you don't leave a bunch of money to your child. Now, if they're already on government benefits and you leave an inheritance to your child, then what would happen is they're going to lose their eligibility for that program. They can get it back by moving their money to a special needs trust at that point. But remember, once they have the money in their name, they're legally entitled to it. You've lost the opportunity to use that third-party special needs trust, the one without a Medicaid payback. And so it basically hurts your other kids. In other words, if I say, all right, I want to leave this life insurance policy to Angela and I forget to send it to her trust and I die and now she has it in her name, well, she can move it to a first party special needs trust, but when she dies, Medicaid's taking it. Whereas if I would have planned ahead, any leftover money could have gone to her brothers and her sister. Do you see what I mean? So the planning really protects the assets so that they can go to other siblings. So it's great to get it planned ahead. In Texas, we can reform a will So if the money passed to that person under a will, it is possible to reform a will, but it's going to be a lot of legal fees and a big hassle. And if you had the money go to that person by life insurance, we can't do anything about it. Or 401k or IRA, we're just stuck. Okay. Same thing with teacher retirement. A lot of times we have problems with TRS because we can't go back and make changes. So you always want to be thinking ahead and planning if you can. And like I said, hopefully you got a long time to get it done.
I do have a question.
Okay.
We did our will, we set up special needs trusts for my son already, a long time ago. How do I know if they reported it to SSA and all of that you were talking about, making sure it had to be reported? How do I know if they did that or not?
Okay, that's a great question. So let me clarify that. You have to report it to the Social Security Administration once it is funded with the amount of money that would cause disqualification. So let me reword that. That was confusing. If you have more than $2,000 in that trust, if it's not a special needs trust, your child's not eligible for benefits. Most likely your lawyer did not report that if you didn't fund it. You know, I think you would have known if your lawyer reported. It's not really on the attorney, it's on you. Now, we typically will help our clients do it, but if you opened your trust and you did what's real common, just stick a $10 bill on the end and say, hey, my trust has $10 in it, then you don't need to report that because it doesn't matter if that's a good trust or a bad trust, your child's still eligible for benefits. But once there's enough money in there to where now your child would not be eligible unless this is a special needs trust, you must turn it in. Social Security Administration has a whole review team. That's all they do is review special needs trusts. So if your trust is funded with more than 2,000, you need to get on it right away. If it's not, then you're okay. Where we see a problem a lot of times is when someone gets a medical malpractice settlement or a personal injury settlement, and because that settlement belongs to the individual with disabilities, you know, say I have a car wreck and Angela gets paid $50,000 for being hurt. That's her money. So I have to put it in a first party trust. I've got to report that to Social Security. I've got to let them look at the trust, make sure it's okay. And if I don't do that, and like I said, 3 years later, they say, oh my goodness, you had a trust. She had all that money in there. Let me look at your trust. Nope, don't like it. You got to pay us back. 3 years worth.
So how do I go about reporting it? There is more than that in it. He doesn't qualify for SSI because he's still under our income and we make over the limit, but he does have the HCS waiver and Medicaid benefits.
Okay, since it's HCS, it's under Medicaid. You just need to give it to Medicaid. Now, I will tell you, Medicaid is much easier going than the Social Security Administration. So once he hits 18 and SSI kicks in, you're going to need to turn it into the Social Security Administration too. And they are pickier than Medicaid. But for now, just make sure Medicaid knows that there's a trust and here's the money in. And it's confusing. There are some caseworkers that will say, oh, you don't need to tell us, it doesn't count. But that's actually not accurate, but it's sort of a misunderstanding. You do want to get it reviewed. You want to be on record as having told them about the trust. And then if they don't review it, that's their problem. Now, Medicaid, by the way, they don't ask for a payback. They're different from Social Security on this. If it turns out that they say, oh my goodness, this trust didn't count, or this trust didn't qualify as a special needs trust, and we gave you Medicaid for 3 years, they don't make you pay anything back. It's what they call a voluntary repayment. I've never known someone to say, sure, I'll pay you back. They usually say, oh, no, I'm not going to pay you, but thanks so much for the Medicaid. Social Security is different. They'll say, oh, here's the bill. This is what you owe. Okay, so Social Security, you got to be extra vigilant about getting it reported to them, but you should get it into Medicaid just so you're not accused of anything. And because it'll be good to get it, you know, taken care of now, because what if there is a problem? Then let's get it fixed now, and they're not going to make you pay back.
So I would just report it to our caseworker, like that does our yearly review for qualifying. Okay, perfect.
Yes. Yeah, when you go through that yearly review, just make sure you say we have a special needs trust, it's funded. Some lawyer told me I'm supposed to tell you that, so I'm telling you, do what you want with it. Okay.
Yeah, I've never told them. They've never asked, so I've never said anything. So I need to make sure I do that this year.
Yeah, tell them that. Yeah.
Okay.
And I'd put it in writing so that you have proof that you told them.
Okay, perfect.
You know?
Thank you.
Mm-hmm. Great questions. Anything else?
Thank you very much. It's really nice presentation. And I have a question. If I have only limited funds, suppose I have 15,000, and is it a good idea to put in a Roth IRA or able accounts? Because IRA account, I can invest in any stocks without any fees and no tax, no fee on the what else? No fees and nothing, right? So what is your opinion?
Okay. It was I couldn't quite hear the beginning, but I believe you're asking me if you have about $15,000, what's my advice on a Roth IRA versus an ABLE account? So what I would consider is I would figure out, am I trying to protect government benefits? Do I want to make sure my child is eligible for SSI and Medicaid? If that's what I'm concerned about, the ABLE account or special needs trust are your only options where that money won't count. If you just put it in a Roth IRA and the child could convert it to cash, that is now an asset, which means no eligibility for any kind of Medicaid program or SSI. Now, if you're not worried about those programs, then obviously that's a whole different way to evaluate. But if you're worried about keeping those benefits programs, you know, being eligible for those programs, you've got to move that money to the trust, a special needs trust, or the ABLE account. The ABLE account, if it's 15,000, that'd be a perfect place to put it, because if you go create a special needs trust, of course, you're going to be paying attorney's fees. But if it's more than 15,000 and you need to get some money somewhere, or you want to do long-term planning, third-party special needs trust is always the best way to do long-term planning, and it doesn't have the Medicaid payback on it. So, and the Medicaid payback on the ABLE account, they will let you pay for a funeral. They'll let you pay some expenses. So having a little money in the ABLE account is just fine. But just remember that if, you know, you keep building it and building it and building it, in Texas anyway, Medicaid's going to take it eventually when there's a death.
Thank you very much. Thank you. And I heard that actually is there a number of transaction limit in the card actually? If I put money in the ABLE account and if I took the debit card, only couple of transactions.
Yes, there is a limit. It depends on the state. In Texas, I think we get 2 transactions, or it might be it's and then you pay, but the pay, it's maybe $1 a transaction. So you do get, and I wish I would have looked that up. I should know. And with my daughter, I do have a Texas ABLE account, and I do a couple of transactions, and I've never had a fee. But I think it's either 2 to the card and maybe a couple more. It's not a lot, and then you do start paying maybe $1 a transaction. So if it's something where you're going to constantly be doing transactions, you do want to look at that. And I'm sorry I don't know the exact criteria, but go ahead and just look up Texas ABLE, and it's all there, so you could read about it. Or any state's ABLE, they'll have it out there on their website.
Thank you very much, Alison. Thank you.
You're welcome. Anyone else? Okay, well, if you all have questions later on, feel free to reach out to my office. There's my number there on the screen, and my email address is there as well.
Thank you, Allison. We really appreciate your expertise and your time. And we just thank you everyone for attending.
Thank
Just
you.
let
So
us
grateful.
know. Yeah.
Thank you so much.
That was wonderful. Thank you.
Yeah. Let us know if you need any follow-up. We can help you.
Okay.
Thank you.
Thanks,
all.
everyone.
Mhm.
Have a
you,
good
Allison.
night.
Good night.
Good night.
Okay. Bye-bye.
Bye.
Bye. Bye-bye. Thank you.